So I'm just going to talk about the work that the competition authorities do, the kinds of issues that they grapple with, and also just putting it into context in terms of some of the broader theories and the principles underlying some of the work that is done. And I'm going to use some case studies to illustrate those points. I guess, as Kevin said, this can be a bit of an arcane subject, but I think these days, there's been enough awareness of competition law and policy. There have been some major cases. Recently the construction sector saw the uncovering of many cartels, which became a big story, which was well covered by the media. Even before that, there was the bread cartel, also very well covered. So I think in terms of the relationship with the media, I would think the authorities have gained some prominence, and there's been a lot of good work that has been done. Of course, some myths still persist, which we'll address throughout the presentation. But one thing that's still glaring is that when people talk about competition law and policy in general, be it in the media or even business people who are not necessarily competition practitioners, they often think of it as about cases and also just as about someone having done something wrong, prosecuted, and then we move on, and don't always link it to the broader structural issues in the economy. So I suppose as a starting point, I'd like to ask you a question. Why do you think we need competition law? And what role do you think it serves in society? It is about ensuring that there isn't exclusion in the market. But ultimately, the end goal is the consumer, to ensure that consumers pay reasonable prices, they have access to quality products, they have choice. And there are many ways that that choice is undermined, and competition policy is one sphere of regulation that tries to address that. So just in terms of just the history, I would summarize it as a tool of economic reform and also open access. And by open access, meaning open access to the economy, opening up opportunity for small players to play, for multinationals to come in, because that's often a case in South Africa that multinationals often feel that in this economy it's too concentrated, barriers to entry are too high, it's too difficult. So the institutions were introduced in 1998. There was a competition policy before then, but it wasn't completely dormant or passive, but it wasn't as active and as prominent as it is now. And it was also not independent in the sense that the competition authorities used to sit within a department, not just in terms of budget and accountability, but literally in terms of their operations, their strategic thinking, the kinds of cases they would take. Whereas post-1998, what happened is that independent institutions were set up that would then have powers to investigate, to prosecute, and to adjudicate competition matters. One thing that often happens is that the institutions sometimes get mixed up, but there's the Competition Commission, which would be the point of entry, so to speak, into the competition law, where those authorities investigate. They're the ones that initiate the cases. And then you have the Competition Tribunal, which sits as an independent institution, where the commission then takes the case to the tribunal, and of course, those companies that are accused of certain practices would then be allowed to also ventilate their case at a neutral platform. So it isn't as if government or an agency just says you've contravened the law, this is the fine. There's actually a legal process. And on top of the tribunal, there's the Competition Appeal Court, which then any appeals that emerge from the tribunal process would get there. And I suppose various theories have been advanced about competition and development, that it is a way to open access, as I mentioned, across the world. In many countries, there's a competition authority. The US was the first one to have antitrust regulation, as they call it, about 100 years ago. And the idea there was the same. There were robber barons, as they were called then, the Rockefellers, the JP Morgans, who were controlling industry, and it was felt that there has to be a state response to this, not to curtail the free market, but actually to make sure that the free market is free and it's not monopolized, it's not thwarted, so that companies compete rather than finding ways amongst themselves not to compete, or where they're dominant, finding ways to exploit consumers. In South Africa, it has another layer, of course, given the apartheid legacy, where the economy was isolated. It developed along a very extractive industry path, which is very capital intensive. So the industry that emerges is big mining houses and big finance houses that support them. And there isn't much of a development of a broad-based manufacturing sector. Even the manufacturing sector that emerges supports mining, and government policy tries to carve out different sectors for different players. So in beer, for instance, unrelated to mining, but kind of illustrates the point, the government said SAB, so there was a beer industry emerged, though it was fairly competitive, but in the 60s, government was like, okay, SAB, you do beer, the distill guys, you do wines and spirits, you don't compete. The same with also lots of state-owned enterprises. Mining companies, you need chemicals, you need fertilizer, we'll create a state company, Sesol. Or you need steel, there's IXCO, but it's not open to private market forces. In agriculture, you want to be a farmer to produce, go ahead, but you're going to sell your produce to this central buying operation at this price. And we're going to control that price. It's not going to be a factor of demand and supply, and we'll even manipulate demand and supply to get the price that we think should be the price that consumers face. Diamonds are another instance where a company is finds a way to concentrate itself, but of course government doesn't challenge that. It's you control the diamond supply, great, foreign exchange, go ahead. Doesn't matter that you're essentially creating an international cartel. So that legacy led to extensive intervention of the state in the economy, limited market competition because a lot of it was directed and split up. The cement company is another example where different companies were given different regions in the country and you couldn't go to your neighboring region. So if you're a builder at the border of two regions, you were told this is your region, this is where you have to buy cement. You couldn't go to the other side and say, can you give me a lower price? That was just not allowed. So 94 came and there was a sense, of course, you know the rhetoric, white monopoly capital has to be constrained. And of course, there was also the global agenda, the World Bank, IMF, saying you need competitive markets, you need to liberalize your trade. At the same time, you also have to liberalize what happens within the economy. You also have to privatize, and that's exactly what happened. And along that, a competition policy was born to ensure that that liberalization actually happens. So just going into some of the case studies that I want to, before I go into some of the case studies, so what has happened over the past 15 years? You basically had a new authority that was independent. At the beginning, there weren't many advanced competition law and economic skills, especially not the ones that would be able to meet the tests of the new legislation, which was quite sophisticated. So you find that in the early days, a lot of what the competition authorities did was merger control. And I think that had to be done because that's compulsory. In our legislation, companies that are merging, that are of a certain size, have to notify their transactions to the competition authority. So there's no discretion there. The authorities had to get up to speed immediately in merger control. So that happened, and in the early days, I can't think of many prohibitions or even many conditions. The authorities were still gearing up. But the good thing about merger control is that in learning, in assessing different transactions, you get to learn about different industries. One of the earliest prohibitions I can think about, though, that was more, well, not too early, 2006, was BCX and Telkom when it tried to merge back then. And you can see that by doing such a transaction, your staff gets a lot of insight into telecommunications, how it works, what competition is like. And such experience can then be useful later when you're tackling other types of cases. And even early on, the Commission was very good at finding cartels. So, cartels don't require a lot of analysis. It's more evidence that these people got together at this hotel, set up prices. But there isn't a sense, or you're not required to show the economic effect of a cartel. It's assumed that by getting together, colluding, you will be harming consumers. Prices will tend to go up. You might fail at your cartel, but the law isn't interested in that. It's seen as the worst kind of anti-competitive behavior, and so it's assumed once you have the evidence, you can prosecute. So in healthcare, for instance, all the hospitals would get together and all the medical aid schemes would get together, and then they would negotiate as collectives for prices and tariffs, etc. That was obviously seen as a cartel. You can't have an industry getting together deciding prices, much as the state used to do. You're still having outcomes that are not determined by the free market. But of course, recently there's been a lot of debate as to, in healthcare, can you really expect each hospital to negotiate with each medical aid scheme and get efficient outcomes, or is healthcare a different kind of industry? But nonetheless, in the early days, that cartel was bust. The different associations settled the case, and they no longer got together in that way. There were now bilateral discussions between each player in the industry. The bread cartel, of course, is the famous one. Lately, construction. But even in the early days, in many intermediate input industries, chemicals, pipes, cement was an ongoing one. You had cartels being uncovered, and this was facilitated by a corporate leniency program where parties to a cartel, the first party to come and confess would get some leniency, and then the rest, of course, would get prosecuted. And talking about the myths, I think this is one area that's often misunderstood, the whole leniency aspect of the authorities, because it's seen as companies getting away scot-free. But I think it's important to emphasize that only the first person gets away scot-free, everyone else gets prosecuted, and also to emphasize the value of the information that comes from that first player. Because in most cartels, you really wouldn't know if you don't have inside information. If you're an investigator coming from the inside, it's much easier when someone kind of blows the secrecy and discloses. So mergers, cartels were doing well, but another power that the competition authorities have is to tackle abuse of dominance. And this is a difficult one because, of course, there's an element that says that dominant firms got there because they deserve to be dominant, because they were innovative, because they outsmarted their rivals, and therefore you shouldn't be punishing them for dominance, which is accepted. So the tests that you have to fulfill to prove that somebody has abused their dominance are quite high. You have to prove that there has been a substantial lessening of competition in that market. You have to prove the exclusion, if it's exclusionary conduct. You have to prove that the prices were excessive. It's an excessive pricing case. And in most of the cases, you also have to entertain the defense that the company would have in terms of efficiency. So in a sense, they can concede that yes, this practice was anti-competitive, yet the efficiency that comes from that would outweigh it. Because of all of that, it's been very difficult to prosecute abuse of dominant cases. So there's been about, I think now, 9 findings, because there's been a recent one with Cecil, another one with Cecil, and only 3 companies have actually paid fines in 15 years. So SAA, Fosco, and Telkom. And you'll note SAA paid fines twice, which goes to the other myth that's often played about in discussions that competition policy doesn't go for state-owned or state-aligned enterprises. And all 3 of them actually have some significant state participation. SAA in terms of ownership, Fosco, the IDC is a prominent shareholder, Telkom, the state is also a prominent shareholder. It's not surprising in a sense that the companies that have been found to contravene abuse of dominance are companies that have had relationships with the state in the past or currently, because it is that those restrictions and that creation of monopoly that creates so many problems in the economy as we speak. Okay, so just delving deeply, because as I say, there's often a sense that there's a case, but there isn't, the context of where this practice comes from, and also the enduring problems that often exist even after the case has been prosecuted. And I think this is the other difficulty with something that the media could take on more in terms of assessing the effects of cases, remedies, long after the case has been prosecuted, to go back and to see what has happened, what has changed, what are companies doing. So in agriculture, as I mentioned, previously there was a system of very extensive state support for agriculture. Some of it good. So in terms of building infrastructure, training farmers in terms of irrigation, etc. Something that the South African government did for decades, since 1910 up to now. And you can see why that would be efficiency enhancing support. At the same time, that support obviously excluded black people and also encouraged a lot of collective thinking in terms of having gathering all your produce into one single channel and pricing in that way. And so when deregulation came, you can imagine the theory was that, okay, you have this agricultural sector, it's not very dynamic, everything is done collectively, let's introduce competition. So a lot of the cooperatives, AFGRI is made of many old cooperatives that were no longer cooperatives, state-sponsored cooperatives, but became commercial enterprises. And that's where a lot of the problems in privatization happen, in that you have a state-aligned entity becoming private, but not necessarily changing its behavior, because then you assume, oh, now it's private sector, it's efficient, it will care about shareholder returns, it will ensure that it's innovative. But in a concentrated market, that doesn't necessarily happen. And so you find that the same cooperatives find ways of replicating that old model even under deregulation. And of course, the simple way of doing that is simply to run a cartel. So you're now told, you're now competitors, you're no longer in this one cooperative. And the market says, oh, no, maybe this competition thing is not what we would like. So we would go back ourselves by forming a cartel, which obviously falls afoul of the law. And I suppose another thing that happened is that, given this long history of state support, there were lots of dominant players, but post-94, not many entrants, because you already have companies that have benefited from soft loans for decades. They've built capabilities. And so it's very difficult to say, we will privatize, there'll be competition, it will be efficient, because the there'll be competition part doesn't happen, partly because of the behavior of the firms themselves, but also because the market structure has moved on. It doesn't lend itself to new entry. And so in that case, you had investigations at the Commission since 2006, which at different parts of the value chain exposed collusive behavior. But also not just collusive behavior, also abuse of dominance type behavior. So in the Western Cape, for instance, you had a baker who was threatened by the other bakeries that are owned by corporates in the area to say, we're going to price so low until you're pushed out of the market, and then we're going to raise our prices up again. Once you're out, implicitly being that, well, if you don't want that to happen to you, you have to price with us and not compete with us. So that's essentially how that kind of behavior was uncovered. That case led to the uncovering of other cases, and while it was happening, companies came forward to then reveal other cartels that were happening. All the major companies came forward, Tiger Brands, I forget who else, but Pioneer was the last one to come forward. Foodco also came forward. And Pioneer tried to fight some of the cases, but actually ended up paying more than everyone else because when it was time for them to realize, okay, we have to settle, so many of the other co-conspirators had revealed their participation in many other cartels. So it was an interesting case study of how, perhaps there were some naive assumptions about deregulation. There were naive assumptions that agriculture and agro-processing were functioning happily now that cooperatives were no longer in place and everybody was happily competing. But it also showed how at different levels of the value chain, you can find new entrants being excluded. So even if somebody doesn't think they want to have a major agro-processing or a major milling plant, all they want to do is just to be a small bakery in the Western Cape, they can't access inputs because the wheat that they need is being produced at a high price by big dominant firms that have formed a cartel. So they can't really get cheap inputs. At the same time, even in their own market, they're being threatened to play along with the club or they'll be pushed out. So I think it highlights some of the challenges that new entrepreneurs face when coming into markets which have entrenched anti-competitive behavior. And also, I think the other important thing that comes from this is also what we assume about competition policy, in that, once again, the assumption is you bust a cartel, everybody confesses, and then they move on, and now they compete, so prices will come down, which is the theory, which happens in most cases, which happens probably in the long run. But in the bread value chain, what's been found is that prices haven't dramatically declined because of other factors like international prices, like fuel costs, transport costs. And so, as a government thinking about policy, one can't place an over-reliance on competition policy alone to deliver low prices. Because even when you've bust the cartel, there's got to be follow-up work in other areas to ensure that entrants can come in, to ensure that administered prices are low, access to finance is available. And I think that's one of the other myths, I suppose, that tend to be perpetuated, that competition policy is all you need and the market will then go on to sort itself out. Okay, the other case study I was going to talk about is telecommunications, which I'll briefly touch upon because there's been a lot of activity in this sector. And it's also a sector fraught with anti-competitive behavior. And it also makes you think about some of the issues that have caused this. Or let me say was fraught with anti-competitive behavior, because a lot of the cases are now behind us, but who knows what's still out there. Once again, a sector that's very state-dominated before 1990. Telcom used to belong to what was then the Department of Posts and Telecommunications, which might be coming back. But then it was privatized. And the idea, once again, was that a private telecom would be great for citizens, prices will come down. And the way the privatization happened was that there would be privatization, but there would also be liberalization in terms of the entry of new players in the form of a second network operator. But it didn't quite happen that way. Privatization happened, but the state still retained a stake in telecom. Liberalization happened, but after 10 years, and a very slow process of getting in the second operator. And in all of that, you've got technology moving, you've got the internet becoming a major force in the economy, and you have new companies that are trying to offer value-added network services. But the only way they can do that is to access telecom's backbone infrastructure, because essentially it's a natural monopoly. It would be inefficient for someone to try to replicate a telecom today. What is economically efficient is for telecom to open access on fair terms, on terms that cover its costs, to other players to access that infrastructure. But of course, you can see how this creates a commercial problem for telecom, because it also wants to go into value-added network service provision. It also wants to go into managed network services. And so the terms in which it engages with those emerging entrants become unfavorable. Of course, there was a complaint from the association, and it took a long time. ICASA tried to deal with the anti-competitive behavior, but got mired up in a lot of administrative challenges. So the complainants then came to the commission. It's also one of those cases of concurrent jurisdiction, which is always fascinating because then it creates tensions. Of course, at the commission, once again, the parties came up with a lot of procedural challenges as to why the commission can't be here in this case. It should be CASA, et cetera, et cetera. And 10 years down the line, or more, it finally came back. It went all the way to the appeal courts, finally came back to the commission to hear on its merits. And the tribunal was then taken to the tribunal. The tribunal found that there had been an abuse of dominance in the way those emerging value-added network service providers were treated. But once again, I think these are things that the media has to engage with. The time that it took to get from the initial complaint early in the 2000s and also even late 90s to prosecution that really started being effective started to happen in 2011, 2012. And I suppose I raise this not because I'm saying the authorities are ineffective, but because they are also in the legal system. And so there have to be procedural challenges. There have to be protracted hearings. Whereas, as the tribunal pointed out, there's also a policy way to look at this, in the sense that the Department of Communications, ICASA itself, could have regulated the market in a pro-competitive way in anticipation of all of these issues, and had a very empowered ICASA that would have taken on the case, had the expertise to put in place regulation that would have preempted some of these problems, so that you don't have a case of harm actually occurring and parties trying to remedy that harm. And also the tribunal raised the issue around government retaining a shareholding in Telkom and what that means for its incentives, because now the commercial problem that Telkom has in pushing out its rivals, it's also its shareholders' problem. And so the shareholder is conflicted because, of course, the aim of policy should be lower telecommunications costs. It should be encouraging technological innovation, but you still have a stake in the old incumbent that is not moving as fast as it should. And how do you balance those two interests? It might seem obvious, but then of course it gets caught up in institutional dynamics in politics, and perhaps the dynamic objectives get overshadowed by the fact that this is, a bird in hand. You have this shareholding, you're not sure about what's necessarily going to happen to the market evolving, and so you try to maximize what you do have. So it's an interesting case of the interplay between regulation, which in most instances is designed to put in place, so I'm talking regulation in the sense of economic regulation, ICASA, NERSA, etc. That's supposed to preempt problems and put in place regulations that ensure a level playing field even before harm occurs, and how that interplays with competition law, which only really comes in afterwards when the harm has actually occurred, and also competition policy in general. Because of course there's also that distinction between competition law and competition policy. You can have great competition laws, but if your policy around competition in general is not great, it can undermine that. And what I mean by that is if your policy isn't geared towards encouraging new entrants, isn't geared towards ensuring that there's a level playing field, then you'll have those problems. Aviation is an interesting example of that. It hasn't been tested yet, but there's always consistent arguments that the policy is anti-competitive in terms of the subsidies that are given to the state incumbent SAA, to almost the soft trading conditions that they enjoy, knowing that they have government's backing, that other entrants don't enjoy and can't meet in the market, and end up facing high costs, going out of business, whereas their competitor isn't facing the same cost pressures. So they can price as if they're in an ideal world, whereas you're a small little player, you're being hit by the oil price, no one bails you out, and then you're just out. And so that's a case where, it's about competition law versus competition policy. Because in fact, there's nothing in competition law that says you can't subsidize your state-owned enterprise. It's perfectly legitimate. It becomes a competition policy question because, be that as it may, as a policymaker, you should say, yeah, this is not illegal, but what does it do to competition in the market and rule appropriately and create policies that are appropriate? As I say, this hasn't been tested because, of course, there are counter arguments to say SAA does need to have a favorable position because they're the ones that are running the unprofitable routes to Bloemfontein, to PE that are good, that are in the public interest but are not necessarily profitable, and so you can't judge them by the same standard. So there is a whole argument there. The only point I'm making is that there are often things that are about competition that can't easily be resolved within the narrow confines of investigation, prosecution, adjudication, but that actually require more of a greater policy response. I'm not going to go into fertilizer. I mean, I'll just, it's a case that involves Sasol's value chain, where there were problems there. Of course, there's now another case that Sasol has been involved in plastics. Inputs to plastic manufacturing, so polypropylene, which Sasol produces as a byproduct of its operations, which has been found that it's pricing excessively. The Commission argued this at the tribunal, and it was found to be the case by the tribunal. Of course, Sasol can still appeal this. I think what's interesting about that case is that it just also shows just the sheer costs of anti-competitive behavior, in the sense that a lot of the plastics manufacturers have argued that it's cheaper for international players to come into South Africa and sell plastic products than for locals to sell those products in our retail shops, partly because those international players face far lower costs than they face in this market. And part of the reason that happens is that they have to get these inputs from Sasol. So that's still a case that probably will make its way through the courts, because excessive pricing is a difficult thing to prove. Like, what is exactly excessive? Is 20% excessive? Is 50% excessive? One can try to find arguments to say, that that's the required rate of profit that you need in a market. But it has interesting linkages to industrial policy, because of course, if you're trying to support local manufacturing, trying to create local industrialists, as is the policy, and yet your input costs are just completely out of line with everyone else in the world, then it doesn't become viable. So I think I'm going to stop there. I think I've dealt with all the myths as I've gone along, and tried to just share some of the background and the context to some of the cases. Of course, one myth I didn't touch on, because the cases didn't really raise this, is this equivalence that sometimes happens between the way the government interacts with the competition authorities. I kept going on about how they're independent. And often the intervention of government in the proceedings is often seen as interference. And perhaps there's sometimes cases of interference, but a lot that gets missed in the discussion is that the government actually has a right to intervene, for instance, in merger proceedings. Not to intervene directly and say this is what you should be doing, but to intervene in the proceedings, as has been the case, famously in Walmart, but in other cases, AFGRI more recently. So I think that's something that always needs to be reported with that lens in mind, to think, is this action in line with what the law allows a government department to do, or is it not? Is it just pure interference? I think that's one area that has been a bit controversial of late, in terms of also thinking about the independence of the authorities. But it's an important distinction to draw.